Now, some senior lawyers have also weighed in on the issue. I have their opinions up next.
The National Assembly is the body constitutionally empowered to make laws. And even though the National Assembly has ceded some of those powers under the electoral law to INEC, nevertheless, the National Assembly remains the sole body, supreme body if you like, that is empowered to make laws for the Federal Republic of Nigeria. So there is no reason under the sun why the National Assembly cannot pass such laws. Generally, there is the doctrine of separation of powers for the executive, the judiciary, and the legislature. Under that doctrine, each of those segments are enjoined not to interfere unduly with the powers vested in each of them. But that being so, the judiciary remains, again, the sole autonomous body that is responsible for interpretation of law. Now, bearing that at the background, the National Assembly, on the other hand, as I've indicated earlier, is the body that is responsible solely for making laws for the good governance of Nigeria. So in pursuit of doing that, the judiciary can take a look at any complaint arising from the National Assembly or from an interested party. But at the end of the day, the judiciary is enjoined not to unduly interfere in the work of the National Assembly. So therefore, in my opinion, I do not think that the judiciary can stop the National Assembly from legislating.
The law is meant for the public, and if there's any law that go contrary to public opinion, so I strongly feel it's illegal in all its entirety. So the National House of Assembly cannot act in vacuum. They have to do everything in the public interest. So the cardinal principle is to serve the public. That is why they are there, to serve the public in generality. That's why we have a separation of power. The three arms of the government have to exercise their constitutional power independently. So the purported law is still in embryo. So until it becomes the law, extant law, before anything can happen, it can only be interpreted by the judiciary.
The 3 months in which the acting Chief Judge of the Federal High Court, Justice Kafarati, was to act, pending his confirmation or the appointment of a substantive Chief Judge by President Muhammadu Buhari, expired on Friday, March 16. However, the President has neither confirmed the appointment of Justice Kafarati, nor has he appointed a substantive Chief Judge of the Federal High Court to coordinate the affairs of the court. Some senior lawyers are worried about this as they consider it a dangerous trend for the nation's judiciary.
It is the President of the country that has the prerogative on who to appoint as the Chief Judge of the Federal High Court. But at the same time, we have had a convention, a very good one at that. I think it's whereby the most senior judge oftentimes is appointed to become the Chief Judge of the Federal High Court. And from what I understand, or from what I know, the present Chief Judge, or the present acting Chief Judge, is the most senior. And I don't know why it is very difficult for the proper thing, to the conventional thing that has been in place, to be done. We are not saying the President, or I'm not saying the President cannot go down the line, but let us look at, in these peculiar circumstances of our country, let the President, let them do the proper thing. Let them just formalize what convention has already put in place. That is, the most senior judge should ascend as a matter of conventional course to become the Chief Judge of the Federal High Court.